Hi, Sue, can you hear me?
Huh? Yep. We're going live, so that'll take another minute or two and then we can get going.
Okay, I'm gonna get myself settled and come off camera so I can get my earpiece in and my computer up.
Okay. Good.
Hmm.
Okay. So we are live whenever we want to get started.
Good, good afternoon, everyone. Welcome to today's investment meeting for June, let's say 20th or 21st?
20th.
20th, 2024. Sue, can I get a roll call vote for today's meeting?
Angela Banks, Christina Bennett,
Present.
Lois Cross,
Present.
Sheila Goodwin, Emily Hubbard, Shanice Johnson, Yvette Levy, Martell Mann, Bobby Richardson,
Present.
Albert Sanders,
Present.
Doris Walker.
Present.
Six.
So we do have 5, so we have enough for a quorum.
Thanks, everyone. Is Jeff Guelda on? I think it's Jeff today, right?
Jeff is on, yes.
Jeff, I'm going to hand
Correct.
over the reins to you to go ahead and take us through the next steps.
Okay, fantastic. And Sue, I don't know if there's anything you want to say as far as introduction, but I know we have two additional securities litigation firms that are in the waiting room. So I think we're going to have them present first. And Sue, we gave them 30 minutes, correct?
30
For
minutes,
presentation.
yeah.
Right. And so the system currently utilizes, is it Robbins Geller Rudman?
Yes.
For securities litigation, generally we don't, there's since, and we'll talk to them just to get an idea of costs and fees, but in general, these firms don't charge any fees upfront for services. They really get paid on contingency if they get involved in a case. So we don't think there's really any downside in having multiple if everybody likes what they hear and what these groups have to say. But again, we'll kind of find out if that is the case, that they're not charging us anything up front as well. And then there's also some other things that you'll hear me cover with them too, in particular. And this is kind of come up pretty fresh because we have some of our clients down in Florida on the public end that were just recently involved as lead plaintiff in a couple of suits. And what we've been running across is that opposing counsel on these is pretty liberal with, and they do this on purpose because it's a strategy of theirs, is they tie up a lot of folks, whether it's trustees or consultants or everybody else, in depositions, which takes a good amount of time. And then also, usually if you're in a deposition, you want to be represented by legal counsel. So I think what we also want to determine from them is, if that happens, how are those costs being dealt with? So I can tell you when we get tied up in a deposition, it's either the group that's running the class action, if they decide they're gonna be involved in the deposition, represent you and pay the money, or if they're gonna say, no, you're in a deposition, you need separate counsel to be involved. And again, if that's the case, those bills start to add up. So that's just something we'll probably want to hash out and get both of these groups take on. So Sue, anything else on that front?
Yeah, no, I mean, I think the other nice thing that these firms do is we do have domestic protection and coverage with our custodian, PNC Bank. But there's really not been anything on the global side. So that's what we would primarily use, what we currently use Robbins Geller for. But they also do monitoring of our portfolio. And we do get monthly reports that shows litigation that's out there. And then they're looking at our stuff too, so that if anything were to come up, that say maybe PNC didn't catch, they would notify us as well. So I think it would work similarly with any other firm that we would utilize. So it's a good service. I mean, they're looking at our whole portfolio and not just the global piece of it. And we do not pay any fees to Robbins Geller for that service right now. So, all right,
Great.
well,
Thanks, Sue.
I think we have two folks, so I'll go ahead and let them in. We have Motley Rice and then a firm Labaton, who I was introduced to through the NCTR as well. So they work with a lot of public sector clients as well. So they will be second, and then we have Motley Rice first. So, and
Sue, I'm gonna try to dial into my computer instead of my phone, so I can get less background noise. Thank you.
hi, good evening.
Hello.
Good evening. Good evening.
How you on this evening?
Can you all hear me?
Yeah,
Yes.
Good, good.
thank you all for joining us. So I'm Sue Kane. I'm the executive director here, and we have Jeff from Mariner, but we also have several of the trustees here as well. So thank you.
Good, good. It's so good. I believe that's Chairman Cross there.
Yes. How you doing, brother? How's everything?
Good, good.
See you.
It's good to be with all of you.
Yes.
I saw many in Atlanta at the NAS Pension Conference.
Exactly. Just saw you last week.
That's right. That's right. So we will, I will lead the presentation. I know we only have 30 minutes. I didn't know the format, whether you wanted me to answer questions or whether you just wanted us to make a presentation.
I'll pull
I
up the
think-
presentation, and then I think as we go through, trustees typically ask questions. Were you waiting for another team member to join?
Let me see who's here. I saw Lance Oliver.
Yeah, I'm here, Marlon. I think we're waiting on Meredith, I believe, but I don't see her on the
Okay,
list.
and what is her last name?
Weatherby.
All right, she's in my waiting room, so I will let her in. And then I'll pull up your presentation and, you just let me know when you want me to advance it.
Sure. Okay, you may advance, and I unfortunately I've been traveling, so I haven't really memorized the presentation, but I'm very familiar with what our team assembled with respect to the substance. So you may go to the next slide. I may not follow these slides.
Okay.
Let me just tell you who Motley, and this is a good stopping point. But let me introduce the firm first. Joining me, I have my partner in the securities litigation division, Lance Oliver. He and I share the privilege of co-leading this organization along with Bill Norwall in Connecticut, in our Connecticut office. We also have Meredith Weatherby, who's been with our firm for over 10 years. And we are all in the Charleston, South Carolina office, but we have offices in Rhode Island, Connecticut, New York, West Virginia, Washington, D.C., New Jersey, and Pennsylvania. We are a law firm of about 150 lawyers. And quite frankly, I think that what distinguishes us from potentially other security litigation firms is that we do more than just securities. We have a diversified practice group, several practice groups within our firm. And the reason why that's important is I know that this board has a lot of work on school matters. And you have to make sure that your time is used wisely, and you don't want to be unnecessarily bothered by legal memos and pitches, bringing you and your board a securities case for consideration. Most law firms who do securities litigation only, or where the firm is solely concentrated, or the majority concentrated on securities litigation, they pay their light bill by bringing cases. And sometimes the market just does not require merit-based cases for your consideration. What we normally do is, if your fund has a sizable loss, and by what I mean by sizable, you're about 200 million in equity, approximately 800 million total assets. We can establish a threshold, whether it be $1 million or $5 million, in order to bring a case to your board for consideration. What we find in the marketplace is firms that only do securities, they have an economic interest to bring forward as many security cases for your consideration, whether some of those are merit-based or not, whether they meet your threshold or not. We cut our teeth doing asbestos litigation all around the country. I was one of those lawyers on behalf of school districts who and other governmental entities that needed the nuisance abated from their facilities. That was big back in the 80s and 90s. We also have a medical malpractice wing. We have an anti-terrorism wing. We were one of the first to bring cases against Saudi Arabia and a number of the governmental entities on behalf of the victims of 9/11. We also litigated the tobacco case, where we represented a lot of state attorney generals, which still is the largest settlement in American jurisprudence, over $400 billion. The master settlement agreement was $250 billion, but there were other states that settled outside of the master settlement agreement. Most recently, my law partner, Joe Rice, he negotiated as lead negotiator on behalf of several governmental entities. He negotiated the opioids case. And to date, we've achieved over $51 billion for a lot of governmental jurisdictions across the country. Now, why is that important? How does it relate to securities? Because a securities case will have its basis on some practice area, whether that be some publicly traded company, for example, Boeing, where Boeing has made several misrepresentations to shareholders, or whether that be some healthcare related company, where a publicly traded healthcare company has defrauded investors. So we actually have expertise in transportation, in healthcare, in medical devices, in antitrust matters. And so when we get to litigating a case, we can actually walk down the hall and talk to people who do things other than securities. I'm proud to say we have about 20 some odd lawyers in our securities department. I have been there at the beginning. I helped start the practice along with Bill Norwald and Ann Ritter back in 2008. 2008 was right after the financial collapse, and we used our relationships with the state attorney generals and other governmental officials who we had already worked with in many other cases before to look at their holdings and see whether or not there were any financial institutions that have been defrauded. So that's how we started our practice. We've been doing this practice since 2008, but we've been long in existence, well prior to then. I think what I'll do at this juncture, after having given you that overview, and I'll come back in and talk about one or two cases. I'll ask Meredith to talk about one or two cases, and then we'll take some questions. But I think what we will do is I'll pitch it off to Lance Oliver, who, along with myself and Meredith, actually litigate cases, to tell you how this process works. Lance, I'd ask you start with monitoring, and then we will open the floor. We'll go to Meredith, and then we'll open the floor for questions. Thanks.
Okay. First of all, Lance Oliver from Motley Rice, thank you all so much for having us and for considering us for this job. It's always sort of the greatest compliment that a law firm can get, to have somebody to reach out and consider them and ultimately hire them to represent them. It takes a lot of trust, and we appreciate that trust and we value it. So just thank you up front. Let me just walk through very quickly and very basically how the process works. Any of our clients who retain us, client in your position, the first thing we will do is we'll work with their custodian bank to gain access to their holdings to set up the portfolio monitoring process. The portfolio monitoring process will allow us and you, there's a portal, you'll have a password with access points, and you can go in and you can look at any time the various reports that are generated about securities litigation in your portal. It also allows us to see that portal, and that gives you the flexibility. If you want to go have somebody look at the portal and check on it every quarter, you're going to get a quarterly report from us anyway. You can do that, or you can simply wait for us to reach out to you. We will monitor the data when we see a case that has, a loss of, with a fund of your size, $500,000 or more, maybe $1 million or more, we may well reach out to you. We'll prepare a memo for you. That memo will explain why the case is significant for a fund of your type and size. It will explain very preliminarily, what we think the merits of the case are. We don't bring cases to our clients that we don't think, have merit in general. I am always careful to tell people that, look, we can't predict the future. I mean, if we had a crystal ball, that would be great. Some cases win, some cases lose. But we will bring you our best estimate of what the merits of that case are at the time of filing. And we'll make whatever presentation you would like for us to make. Some boards like a long presentation. Some boards like a short one and say, just let Marlon call the chair and let's get this going. At that point,
Lance, there is a question, if you don't mind.
Okay.
I'm sorry, did you say your name's Lance?
Yes, Christina.
Lance, this is Christina. I'm the investment chair for the board. So question for you on this. So if you do this monitoring across all your clients, right? Then you're going to see, for example, let's say, for example, Boeing, right? And they're in the media right now, and they just, they didn't tell the truth, blah, blah, blah. And the government's trying to decide what they're going to do with that little lie they told. So in that case, it is us in conjunction with other clients to amass a large suit, right? It's not just our fund. It is everyone in. So are these like class action suits? Are you talking about?
Yeah, that's right. So, and I'll just go to step 2, because that's where you're going. Yes, these are all class action lawsuits. So if you filed a case based on our recommendation, we would be applying with the court to make you the lead plaintiff or the class representative, right? So your fund, maybe with a group of other funds who are also interested in the issue, would apply to be lead plaintiff, but there wouldn't be that many, right? Typically, lead plaintiff groups are 1, 2, 3 funds at the most, maybe 4. I typically don't like to have that many as a lead plaintiff. And then that fund or group of funds will represent the entire class of investors who purchased the stock and sold it during the right time frames. And that's obviously important. Just because you bought the stock or you sold the stock does not make you a class member. You have to have bought it and sold it at certain times. And our memo, for every memo we write, we explain, what the current time period is, what we think, you need to have bought and sold. And with our monitoring data, we can tell you whether you bought and sold during the proper time. We do get confirmation of that because you have to sign a certification to the court saying these are our trades. But that's not, it's a pretty scientific process at this point. It's rare that there's any issue with that. That's pretty turnkey, at least with United States investors, because the trade data is pretty clear as to when you bought and sold the relevant shares. Does that answer your question?
It does. Thank you.
Okay. So after we move for lead plaintiff, assume that you get appointed lead plaintiff, then we would go forward and litigate the case. From that point, the biggest question for a fund is what is required of me? Obviously, you would be committing to represent the best interest of the class. That means you're committing to monitor us as counsel, but it's not a highly involved process for most of the time. You would have to put one person up if the case got far enough down the road to take a deposition. That's a pretty basic process. It would take 2 days out of somebody's time. I would need to come visit them, prepare them for the deposition, and then they would have to do the deposition. After that, really what you're doing is consulting with us about the relevant filings, the major events in the case. And of course, at some point, most of these cases settle. I actually do a fair number of trials myself, but most of these types of cases do not go to trial. They'll get pretty close. We got a big one in Twitter a couple years back. We got that very close to trial, like the day before trial. I think we settled it on a Friday and we were picking a jury on a Monday. So I had already moved to California to try the case. But most of the time, the cases don't get that far down the road. So the major inflection points for the fund are, all right, I get a memo. Do I want to be lead plaintiff? You make a decision about that. You apply. If the court appoints you, somebody else may get appointed. If the court appoints you, at that point, you monitor us. You will end up doing a deposition within, say, 6 months of being appointed. So you go do that deposition. After that, the next big inflection point or decision point is what do you do about a resolution of the case when that time comes? All of this happens over a 2 to 5 year period. Nothing happens fast in litigation, unfortunately. I'm an incredibly impatient person, and I always tell my clients, nothing happens fast in the legal world. So it does take a while. So these steps that I'm requiring, none of this is happening in a month. I mean, it's happening over a very, extended period of time. And that's sort of a summary of how these cases usually go and what's required of you. There are document productions that your fund will have to make. We handle that for you. It's not onerous. It's typically some basic trading data and that kind of thing that we'll have to turn over to the defendants. Usually it doesn't require much out of you. We can get most of that from the custodian banks who can confirm your trades. So that is the overarching, sort of how the process works. Do you have any questions about that?
Yeah, I think Jeff had a question.
Yeah, Lance, going back to deposition and process and requirements, resources. So you mentioned that the board would have a representative, but can I ask you if is it certainly within the purview of opposing counsel to depose multiple folks? I mean, while you say you could have a representative, they could say, no, we want to talk to every single trustee. Also, we want to talk to your investment consultant. We want to talk to managers, things like that. And in any of those cases, no matter who's being deposed, is your group acting as counsel to them?
So that's a good question. First of all, no, they cannot. I have never seen a case where a defendant deposes more than one person in the plaintiff's organization. In other words, the board of trustees will have what we call in the litigation world, you guys may know this, a corporate representative. And you're basically putting up a corporate representative to speak for the fund. That's the only witness from your fund that I have ever seen them depose. Could they try to depose somebody else? Sure. I've quite frankly never seen it done, and I don't think they would get that request granted by the court unless it was some extraordinary circumstance. Now, you did mention something that's worth discussing, which is, could they try to depose your bankers or your financial advisors? Occasionally, they do a third-party subpoena to somebody who's advising you. That is, again, extremely rare. I have seen it happen. I remember it happen. I've been doing this. I mean, I've been practicing law for 20 years, but this practice area for 16 of those 20 years, I think I remember it happening once or twice over 16 years. And I don't even remember if they got to depose those people. I do know that if they try to depose, let's just say Morgan Stanley, I'm going to throw something out there. They say, oh, we want to depose Joey from Morgan Stanley because he advised you. They have to subpoena Morgan Stanley. They can't get that person from you. They don't work for you, right? So there are a lot of steps, and we don't represent that person. So it's typically more of a pain in their rear end to do that than is worth it. And the court will say, obviously the bankers are going to say, wait a minute, the investment advisors are going to say, I don't have any useful information. And the court will make the defendant show that
Body odor like a motherfucker, Kendall.
So, Lance, I don't know if there are any more questions, but I do want to give
Marlon, let me just tell everybody to go on mute. If you're not speaking, please go on mute. I appreciate it. Sorry, Marlon. Thank you.
Okay, no problem. I do want to give Meredith some time because I think it's important. She adds a unique voice to our team. And I know we only got 30 minutes, so I want to make sure we work in our Meredith as our important member of this team.
Hey everyone, I'm Meredith Weatherby, and thank you again for having us. And I'm just going to elaborate a little bit on what Lance and Marlon talked about. And I think, what makes Motley Rice special in terms of our relationships with our clients is that your fund will not just be a name on a really long list. We really value each individual relationship with each client, and we tailor that relationship kind of depending on what you guys want. And I saw online your investment policy, but I did not see that you have a securities litigation policy. Is that correct?
We do not. We do not have a litigation policy because we had a custodian for over 30 years. And they took care of some of these class actions. They got involved with that. And so we never had a policy. It was something they provided. And we never dug into it. So we would have to create a policy and procedure if we went down this road. Correct,
Okay.
Sue?
Oh, sorry, go ahead.
So we do have services from our custodian bank right now on a domestic level, just not global.
Sure.
Right. And that is something that we have helped our clients with before, to craft a securities litigation policy. So that is something that we could help you guys with as well. And I think it's really important because each fund, has different motives and what they're looking for in this space. For example, one of our clients, the Employee Retirement System of Rhode Island, they really wanted to take on a case that meant something to them and that where they felt like they were making a difference. So last year we filed a security derivative case on against Meta. So that means we were representing, taking on the role of the company and suing Meta's directors and some of their executives. And that was on sex trafficking, human trafficking, and child exploitation. So the treasurer of Rhode Island, James Diosa, he made a public statement about the litigation saying that, they really wanted to take on this case because they wanted to affect real change in terms of the company's corporate governance. And so it depends, you guys could have your own issues that, cases that you want us to look out for. And there's so many different ways that you guys could really work in this space to really effectuate change, not only in the corporate governance space and making these companies that you guys invest in, making them more profitable, which in turn will help your all your trustees and your employees, but also helping effectuating real change and in the world. And these are things that are going to be making a real difference, we hope. So so there's a lot of opportunities here, and we could help you. And you guys would be contacting us directly. We will always be involved. You can call us up whenever you need us. We're very reachable, and I think that's sometimes unique in terms of the law space. So
let me thank you, Meredith. Let me go to address two things. One, I heard the mentioning of a custodian bank. There's a distinction between hiring a law firm to actively litigate and look into legal matters on your behalf versus a custodian bank who files claims on your behalf once the case is settled. And so regardless of what your contract is with your custodian bank, and hopefully they are filing your claims on all of these settlements, we've gotten into, we've been engaged by different pension funds around the country, and we provide them with a report on when the settlements come out. And some have further asked, well, do you know if our fund has filed a claim? And we can, in some cases, do that work on your behalf, but it is their responsibility under most contracts to file claims, but that is often once a securities litigator has brought a case successfully on behalf of a fund, and that fund has dictated the terms of a settlement. And so I just wanted to make sure that you knew a custodian bank does not replace what we do. In fact, there's a good checks and balances. You get a quarterly report, and on the last page of that report, it will show you what settlements have been approved for that quarter. And you can send that report to your custodian bank and make sure that that institution is actively engaged in filing your claim, because all shareholders ultimately, if a case settles, will have some interest, some financial interest in the resolution of the case. The other thing that we did not mention is our monitoring service is free of charge. So you will not get any bill from us. This is a cost of doing business for us. Now, how do we get paid? Well, ultimately, in the course of us representing you, we're betting, it's a business decision on behalf of our firm that you will ultimately have a case. And what Lance didn't say is these cases can be big. One of the largest cases that has settled in securities litigation is a case that Lance just told you about. He's much too modest. Chairman Bennett may know, and Chairman Cross may know that I'm not as, and sometimes I'm accused of not being humble. But Lance just told you about a case, and he didn't tell you the amount, but it was $800 million, the Twitter case that this firm litigated up to the courthouse. These cases don't often go to trial. That's one of the largest settlements in securities history. I don't know whether it's the second largest or fourth largest, but we had in that case, and in every case, we will negotiate a fee contract, contingency fee contract. If you engage us to bring a case on your behalf, we would separately negotiate a fee contract with either Guelda or Jeff or whomever your consultant is or your lawyer is. We will, or your board chairman, we will negotiate that along with whomever you designate. and we work on contingency fee. And so we could get up to a third. Often our contracts say we will have a third in this case representing you. And if we get lead plaintiff, we're not just representing you, but we're representing all of the shareholders. And so at the end of the case, we will go to the court because all of these fee contracts have to be approved, or not the contract, but the fees. When the lawyers get the fees at the end of the case, the court has to approve our fees. And so we will apply for a fee award before the judge who is approving the settlement. And we have to keep contemporaneous time and expenses such that we hand in, we apply for 25%, 30%, whatever we have negotiated with this fund. And then we have to turn in our time to the court. And the court would then take into account what we did in the case, look at our expenses, and then either grant our fee request and our expenses, which are separate, or lower the fee. In some cases, the lawyers have not done what the court considered enough work on the case to get the result that the judge thinks, and he or she has lowered the fee. So just because we apply for a certain percentage doesn't mean we're going to get it. It has to be scrutinized by the court. So those are 2 points I wanted to make since the issue of custodian banks came up. And also, I don't think at all we talked about how the contractual relationship we would have, which explains why we offer the monitoring for free.
And Senator, just to clarify, it's again, would that each new case that would come up is going to be a new contract, or would there just be a blanket contract for any case you're going to have?
Correct. We would have a new contract for every case. Every matter is a separate matter that you retain us to bring on your behalf. And again, as Lance explained, just because we bring a case doesn't mean we will be, or your fund will be selected as lead plaintiff. There's a whole process for what the court picks as the lead plaintiff. But I can tell you this, since y'all have not been actively involved in securities litigation before, if we look at the opinions of the court, there are really 2 things that guide that decision. Number one, whether or not this fund or the group of funds has the largest loss. And so the court looks at, there may be 10 funds applying for lead plaintiff, which group has the largest loss? But also number 2, the court likes to see new participants, not just the same old funds filing time and time. So there is some rationale to funds who have not traditionally ever moved being involved, because the court considers that those funds may offer a fresh perspective and are not quote unquote frequent filers out here in the industry. I hope that answered your question, Jeff.
Yeah, we're pretty much right on time here for the 30 minutes.
So I have one last question. So Marlon, so for example, let's say that we go and we file, but the judge says, no, Kansas City is going to be the lead plaintiff. Does that mean that you would still incorporate us and represent us if we were one of the other plaintiffs in the group?
There's only one lead plaintiff. And so Kansas City would lead that litigation. There are some times, Chairwoman Bennett, where lawyers from different firms may negotiate working together on a case. So Kansas City might be at the hearing, and Lance has made a persuasive argument as to why St. Louis should be lead. Before the judge issues an order, there is a potential that Kansas City's representatives and and St. Louis working agreement to work together, or Kansas City may need extra help in the case, and they may reach out to us or whoever is representing you to work together. But in no case could we reach that kind of agreement without your permission. But the lawyers, as y'all know, by attending these conferences, we all know each other. And we, for the most part, we have good relations with one another. And so we try to address these things, even though the lead plaintiff position is very competitive. We try to, once we have a case or once we're in the same courthouse, we try to work together.
Thank you.
Any other questions from the trustees, or Jeff, do you have anything?
No, that's great. Thank you.
Do you have any?
No, thank you all so much. Very informative, and very impressed with your presentation. Thank you.
Thank you so much.
All right. Thank you all for joining us.
Thank you. Thank you again.
Thank you.
All right. Bye-bye.
Thank you.
So we do have the other group in the waiting room, unless anybody has any comments before we let them in.
Not at the moment. I'll wait till the end.
Okay.
All right, so I think they're all off. Okay, I will let this, there's two from Labaton that I'll let in.
Yeah.
Good evening.
Good evening to you.
Thank you.
Good evening.
Thank you for joining us.
Thank you. We're very happy to be here, and thank you for the board's time. I just wanted to quickly introduce myself. I'm Hui Chang. I'm an off counsel at the firm. I'm joined by my colleague, Eric Belfi. He's a partner at the firm. He's based in New York. And again, I just wanted to thank you for the opportunity to present to the board and share what we do and the practice areas that we focus on and the types of service that we provide to institutional investor clients. If at any point you have any questions, please feel free to interrupt us and ask us questions. I just wanted to go over a little bit about the firm. We are based out of New York with offices in DC, Delaware, and also recently in London. And we have about 80 attorneys. You know, we're a 60-year-old firm. We primarily focus on securities litigation, corporate governance, shareholders' right litigation, and we provide different types of services to clients. We currently have over 250 institutional investor clients. We wanted to take the opportunity to talk about some of the ways we could assist funds and institutional investors, you know, in participating in actions that could potentially bring returns, you know, recover losses on their financial investments. And one of the ways we do that, we have a global securities portfolio monitoring service that we provide. And what we do is we track closely the portfolio of the fund, and we monitor for any instances where there could be opportunities to recover losses or implement corporate governance changes, if that's something that the fund would be interested in. So we have a team that's dedicated in-house to vetting cases. On average, about 200 cases are filed in the US, securities class actions. We assist the funds in tracking them and checking their exposure if they have any exposure and losses in those cases. And then we make a recommendation at that point as to whether the client, the fund should participate, as a passive class member, if they should take a lead role in the case or actively litigate the case. We provide quarterly updates, more frequent updates once the client, the investor decides to join. And we work with the client to make sure that, they're actively participating in cases or not, if they desire not to, but still continue to monitor their losses and look out for opportunities to potentially recover losses. We do that through a in-house team. We have investigators on staff, financial analysts. We have seasoned litigators with background in finance, accounting. Then the process is, after we flag a potential case, we carefully evaluate as to whether the merits of the case are strong. And based on that, we develop, we make a determination if it's worth diving deeper into the case. If there is, we will, we have an investigative team that starts contacting potential confidential witnesses for us to develop our case. Everything is done in-house, our financial vetting analysis and the in-house team investigation. We spend a lot of resources and time to vet the case. If a case is filed, there's usually a 60-day period window where we are able to spend some time in vetting the case carefully. And based on that, we make a recommendation. If it's, something that would be of interest to the plan, we would make a recommendation accordingly. I think with time, once we get to know the fund and we are able to understand what the areas of interest are in the case, that's what we would do. At times, we may recommend a passive role where you take no action and we just monitor and update you on the status of cases. But the ultimate goal is, to assist the plans and the funds to recover any potential money that could be left on the table through, corporate misconduct. So we're just through that process, we make that evaluation. It's, as an example, we think it's critical for institutional investors to get involved. In a lot of instances, whenever there's an institutional investor, the damages, the settlement recovery is a lot higher. One specific example that we worked on a case, it was against Scana. We represented a large institutional investor, and the co-lead, another lead plaintiff in the case, they were represented by another firm who had made a recommendation to receive a lower settlement for the class by having an institutional investor being in that lead role. We were able to secure, 75 million more. So, just there are a lot of advantages to having an institutional investor be involved in these types of cases. We also not only track all the cases within the United States for opportunities for recovery, but also abroad. That's the area that I specialize in. A lot of, if the fund has investments abroad, those types of cases are a little unique. They are opt-in cases. And that means that in order to participate in any potential settlement in the future, you have to opt in at the beginning. It is very difficult to track. So the type of service we provide will be very comprehensive. We spend time vetting each case, if they don't get consolidated the same way that they do in the United States, and you're unable to participate. There are a lot of instances where we found our clients were leaving money on the table. As an example, in Australia, a lot of recent class action settlements in Australia, you did not have to actively join. You just needed to file a claim form by a certain deadline. So you're opting in to be able to collect. So we were able to step in and advise our clients on that. We think it's critical for institutional investors to be able to maximize recoveries in any way that they want and can. So that's what we initially do for clients. Once they decide to join litigation, we look for ways that it would lower burden on the client, given the resources limitations sometimes and the time constraints. So one way that we do that, for non-US, we undertake all the work. So you can outsource all the work for us to take on your behalf. A lot of times they are the clients are not aware that they can pretty much take a passive role depending on the case and the jurisdiction. But without them signing up first, they would not be able to participate in any potential recovery. So that's one of the types of services we provide. I know, I think the fund may have some exposure abroad that, if they would be interested in participating, collecting, no firm currently is, unless you are opting into a specific service, they're automatically filing or vetting those types of cases. They're very difficult to track. We have a system in place that we are able to connect with a lot of foreign counsel. We currently have clients in cases all over Europe, as an example, Brazil, Japan. And in that way, we're always looking for opportunities for our clients to be able to recover their losses in different jurisdictions. I don't know if anyone had any questions at this point.
One thing I would just point out, I know we just threw a lot of information at you, but
Yes.
basically this service it's at no cost to the fund and no obligation to the fund. So we're going to provide you with information and we're going to take the risk that you may never do anything. And that we, as we said, we have over 250 different clients. And so we know that a certain amount of clients will do these and a certain amount won't. So we just want to build a bigger basket and know that maybe there will be a situation that arises that makes sense for you guys to participate, but maybe not. And that's the risk we take. And so there's no quid pro quo. And this is basically a free service. But most importantly, I think it's really good information so that you can make determinations of whether or not you would want to pursue something or not. To me, you're always in a better position to have this information, even if you do nothing, because if people ever ask, as a trustee, do you pay attention to this? You can say, we look at it and we get information and we've just made a determination that it wasn't in the best interest for us to pursue it, which I think is a better position of saying that we don't look at it. But I know we went through a lot, so I don't know if anyone has any questions.
Eric, you said that it's no cost. How do you guys get paid?
So we have a program and we do this for all of our clients. And basically, if a certain amount of clients do cases and we get paid on a contingent basis or success fee based on those cases, that's how we're able to cover to give this service at no cost. But we don't get anything directly from our clients. We would only get paid if you did a case and the case was successful, and we would get paid out of the case, but never would any money ever have to come from the fund to Labaton.
Okay, thank you.
Correct.
And do we do that with a blanket agreement with you for any case as far as how you get paid, or will you come to us on a case by case basis for a specific structure?
We can do it either way. We will certainly have a monitoring agreement if you decide to proceed forward. That's really a confidentiality agreement that says that if you give us any information, we will treat it confidentially and we will provide this service at no cost to you. If you decide to pursue the litigation, it will always be on a success fee basis. And we usually put that in the monitoring agreement. We can have a blanket agreement if that's easier, but that ultimately is your preference, or you could decide on each case once we present it to you how you want it to proceed. But that would be that's for you, that's your decision.
So another question is, so there's a handful of firms that are out there doing it, and there's larger names, and I think we probably all know who those are. So let's just assume we're using multiple services and they're all probably monitoring the same thing, and something comes up with Microsoft, and then you come to us and say, we'd like you to be lead plaintiff on this, and then somebody else comes to us. I mean, walk us through that kind of scenario. How is that handled? How does this board know who to go with, and what's the protocol there?
So I first of all, I would tell you to have more than one firm in doing this process. Even if the one firm are ours, we tell you to have multiple firms. because firms are going to have different analysis points, and some firms are going to focus on different things. And, you know, for example, we have all the non-US, and there's a lot of firms that don't focus on the non-US. But even in the US, there's lots of different types of cases that not everybody focuses on. You will run into the scenario that you presented where you have 3 firms and all 3 firms come to you, and then you have to decide, how do we want to proceed? Now, I've been doing this a really long time. Firms do it all different ways. There's no constant one answer. One way to do it is whoever comes to us first, we would pick them. Some firms will do a rotation where they'll go, well, we went with firm A last time, we'll go with firm B. Other firms will analyze the materials that are set forth to the fund and make a determination of who they think is in the best position to prosecute the case. As we talked about earlier, we do a lot of work with confidential witnesses, and you might take a look at our report and say, well, Labaton's got all these really good confidential witnesses. They're going to be in a much better position to prosecute this case than the other firm, or conversely, it could be the other way. And so you can do a real merits analysis, but a lot of funds, I find, sometimes don't have the time or resources or don't want to be burdened with this. So they go to some of these other processes where they rotate or they just decide whoever comes to them first. From our standpoint, we always want to do merits, but conversely, we do understand that you have limited amount of resources at every one of these funds we deal with. And so we don't want to make this a burden. So I would suggest whatever you think is the easiest way to proceed.
And as Eric mentioned, you know, we, for the non-US side, we also don't charge. It's completely complimentary service. That is not even, if there is any fee involved, it would be to outside counsel and the local funders we would partner with. And in that situation, we are able to, because we have a large group of clients who are typically joining the group action, we're able to negotiate better terms on behalf of clients and also raise opportunities. As an example, you know, we had cases in the UK that were not even filed. They were just a pre-suit settlement negotiation. We were able to negotiate directly with the defendant. So, you know, we're always looking for different opportunities where we could potentially maximize recovery. And, you know, in the non-US example, without any burden to clients. And, you know, the threshold, typically, I think the concern is if you don't have a significant damages, is it even worth taking the time to join these types of cases? And also, you know, it really depends on a case-by-case basis, but you know, if you're balancing, you know, the investment, the time investment and the burden, it may be worthwhile just to pursue. And, you know, in non-US case, there's just no burden whatsoever and no cost, no risk. So we will make a recommendation. And when Eric touched briefly, you know, other firms don't focus on non-US. I know we provide it as an additional service in order to, you know, ensure that clients are being covered in all different ways. And we are able to consolidate different cases in one single report and make sure that, you know, you're aware, familiar with all the different actions that are out there and the type of exposure that you have in your portfolio. And Erica, do you talk about Delaware, our Delaware practice?
Yeah, just real briefly, we've covered the class actions, whether they're in the US or not, outside the US. The other area that we do is we do corporate governance, either derivative or direct actions in Delaware. There's obviously one of the very high profile ones that we didn't do, but that is currently there is the Tesla one. But last year we did the Dell case that we recovered over $1 billion for shareholders. And what was interesting about that case, that was brought by a very small labor fund in Western Pennsylvania that is only a couple $100 million itself in total assets. And what's interesting about Delaware actions is that, you know, in the class actions, the normal federal class actions, it's whoever shows up who has the largest financial interest. In the Delaware actions, a lot of times it's just who shows up with the best complaint. And so there are definitely going to be situations where a fund like your size could have a case that is massive. I mean, the Steamfitters 449 in Western Pennsylvania is, like I said, it's a couple $100 million fund, and they were able to recover $1 billion from Dell. And so, and that obviously goes to all the class members, but it just shows kind of the power. And, you know, my pitch on this that I always tell people just more generally is you're investing in this market. Generally speaking, the federal government does very little to regulate it. The only people that really regulate this market are the private attorneys, such as our firm. But for those firms doing these cases, but most importantly, with institutions stepping forward, these cases don't happen, and you don't have the oversight that you need on public companies in our market. And that's why I think, you know, if deciding to do it, I think it's very important because, you know, you guys obviously have a significant portion of your portfolio invested in the public markets, and you want to make sure there's good oversight of those markets.
Is there any questions at this stage, or? Joey, Eric, I touched earlier, you know, with our case evaluation team, the way we do it, we are very selective in the process. We vet cases carefully and spend a lot of time and resources evaluating each case before making a recommendation. And I think that translated well for us because our dismissal rates are lower than, you know, our peers because we are more selective in that process, you know, and we're very comfortable in making negative recommendations specific to cases. So I think earlier you mentioned if you have different law firms looking at the same case, making a recommendation, there may be instances that we are making a recommendation that differs from the other firms. And, you know, we will explain the reasoning why, or even, you know, if we're not recommending against a case where we're making a recommendation that you don't take an active role, you're just passive, you just do nothing at that point. You know, I think it's always nice to be able to compare the different strategies being pursued, you know, the analysis being provided. In the context of non-US, we have been doing this for a lot longer than other firms. And I think we do it in a unique way that we are able to vet, you know, all the risks in one instance at once. But also we are not taking anything. We don't, you know, we are not charging for the service, but also we don't accept any referral fees from outside counsel or foreign funders. So that way, you know, we're making whenever we're making a recommendation one way or another, you just know that it's conflict free. You know, we're not doing this because we're getting something in return from any party. So in a way, that's another way we provide a comprehensive service, you know, on the portfolio and make recommendations to join or not.
So just locally, just one last thing. We do work with a lot of them.
What was the last?
I'm sorry. We lost you there a second, Jeff.
Okay, Jeff, go ahead.
Sorry, I might be on a delay, or can you all hear me now?
Yeah.
Yes.
Yes.
Can you hear me?
Yes.
Okay, I've got my connection's not the greatest here, but my question was, what was the last non-US case that you successfully brought with a public pension fund investor as a lead?
So they don't act as lead, is a little different for non-US. You are part of the group. So in a way, you're not standing out in any way. You don't have to provide discovery. There are a lot of jurisdictions that reliance is not even required. So it's very passive. What we say is you sign for the case and we undertake all the work on your behalf. That means, you know, if there is a situation we need to provide a custodian statement to show that you held shares, we would contact the custodian directly and we wouldn't even bother the client with that type of work. And then we have actively monitoring right now cases. We have 75 non-US cases currently. And I would say for probably all of them, we have a public pension client.
What are the last couple of cases that
most recent? We have a French case against Vivendi. That one settled recently. That one was ongoing. It started in the US And then it was some part of the claims ended up in before French court. That one was initiated, settled for a sizable amount. So that one we had public pension clients, US based, also involved. Steinhoff is a massive case in the Netherlands. That's a very plaintiff-friendly jurisdiction that settled for 1.4 billion. We also had case clients in that. I mentioned Australian cases recently, AMP. That one, we only filed claims for clients. So in that situation, we always look for on whether there is a requirement to register. If there isn't, we don't want to bother clients with even signing one-page document is not something we would push on, because if it's not a requirement to join and you can only collect the money, that's the best part. So AMP is a good example. It was settled for 125 million. Our clients only filed a claim. We filed a claim on their behalf. And what that involved was simply emailing the fund and asking them if we could sign a claim on their behalf, and then collecting money. It was just as simple as that. Yeah,
some of the jurisdictions outside the US are essentially glorified claim forms, the way we would do a claim form in a US class action. But the difference between the US and there is you actually have to opt in. You actually affirmatively have to do something, as opposed to the claims filing process that you would have on US class actions.
Correct. And also the difficulty is that there's no one monitoring really this, the custodian banks usually will send notices about, you may have exposure to this potential case in Australia or any other foreign jurisdiction, but they won't do anything about it. So what we have done is, we have clients who will forward us these notices for their comfort, but we already are monitoring and tracking these cases. I mentioned earlier, currently we have about 75 cases we're actively involved in, or actively involved as liaison counsel on behalf of clients. And then we're able to go back to them and say, your exposure was X, you lost potentially X, and then let us assist in a recovery. There was a recent Danish case we helped settle. That one led to a 40% recovery rate for clients. And, it was a complimentary service that we provided. The client in that situation, they signed the documents to participate in the case, and we took care of the rest. We provide quarterly updates, and then hopefully at a later stage, just notify the client. And then we handle also the settlement distribution for the non-US side. So it's really comprehensive from beginning to end.
So I was going to say before, we appreciate your time. Just I guess the last note is that we do work with a lot of Missouri funds. We work with Missouri Public School Fund. We also work with almost all the Kansas City funds. We also work with some of the other St. Louis funds. And we do work with a lot of teachers funds. We work with Arkansas Teacher. We work with Chicago Teachers Funds. So we work with a lot of funds in your geographic area, and we'd love the opportunity to hopefully be added to your list so you could see the services that we provide.
Any other questions?
No. Enjoy the presentation. Thank you all so much.
Thank you for your time.
Thank you.
Thank you.
Thank you. Good evening.
Good evening.
You too. Bye-bye.
Okay.
So they're off now.
Okay.
So any general thoughts?
Well, I know they say if we have a case. In the past, have we ever had any cases like that?
No, we've never had a case because we've never had a security litigation firm. We always just had the custodian file claims for like class actions but we never had somebody going out and looking proactively. And again, I'm going to say that I have been trying since 2009 to get a security litigations firm in front of our board. However, our previous executive director was adamant that he would not bring it to the board. And I know Lewis is my witness, and Helen and all the past trustees would just, cringe because it was something he didn't believe in, and was very adamant that he felt that the US Bank was doing good enough, and would indicate how much claims had been filed by US Bank. But that, I don't think he understood the difference between the custodian and a litigation firm. I'm seriously trying to find an outlet here before my phone dies.
Uh-oh.
Here we go. I'm gonna.
Hopefully, that's all, and as my mom would say, it's water under the bridge, so it's a new day, and hopefully we can secure someone, especially since they don't charge unless there's something. They're monitoring everything for free, both of these companies, and I guess we have some more
And
coming.
we have Robbins Geller, they are, but it's really just since 2023. So they are similar to these other firms where they monitor, and then if there's a case, they would come to us and they could serve as they would litigate it for
Right.
us. So we do have that, but it's just been within the last year. So far, no cases identified yet.
Yep. And so I think Lewis, were you on the board in 2009? I think you
so.
were.
Yeah.
Yeah.
So I think
Yes.
so. Yeah.
So Helen, a previous trustee, Helen, Byron, and myself.
Right. No, I wasn't. I got off in. I think I got off in 2007, and I wasn't on then. I don't think.
Yeah. And
Yeah.
we went to a NASP conference in Beverly Hills, and we went to go see Causeway as one of our managers, who's still a manager. But we sat in on a trustee training because we called it the NASP Institute, which used to be where all trustees for the first day just got a bunch of training. And we heard about a securities litigation, and there were three or four of us that sat in on that. And our custodian's going to file for us and get stuff, but I think securities litigation is a win-win for us. There's no cost associated to us. And I personally think that if we're not being charged a fee, then it behooves us as our fiduciary to hire a firm to act on our behalf. And if we get, I always say, my grandma used to say, a penny in your pocket is better than nothing, right? So if they're going to do the work and they're going to act on our behalf, then I'm all for hiring a firm.
I am as well.
I was gonna say, if we do have a case, could we afford them at whatever price they choose?
Well, so Bobby, we don't pay. So for example, it's like me saying, Bobby, I'm going to go and I'm going to fight. You took a loss. Let's say you took a loss on Apple stock, whatever it is. I don't care what stock it is, or the fund did. This firm is going to say, I'm going to go fight on your behalf. I'm going to go represent you. I'm going to do whatever. And let's say we win $100, and they say, great, Bobby, the fund gets $66 and we get $33. So we never have to come out of our pocket to pay. They would just take that's when
Beauty.
they would say, hey, let's make sure we understand if we litigate this for you, this is what our fee's going to be. And for us, like I said, is we haven't spent anything. We would be a win-win. If we win and get $100, great. If we win and get $50, we're still gonna get something. We're gonna get 2/3, right, of whatever they get for us. So it's a win-win for us, and we never have to come out of pocket to pay for fees.
Okay. So they just be on our list. So if we have a case, it can be a year, 5 years from now, right?
Right. They take the risk. Now,
Okay.
what they're going to do, for example, right, they're going to take everything that all the managers we have, right? All the managers we have in this fund, we have all these managers. They're trading all the time. So they report those trades to the custodian, which is now PNC. then PNC is going to give that trade information to the securities litigation firm. And they're going to go through and they're going to look at the data and they're going to see where our losses were. For example, we bought ABC stock for $100 a share, and we sold it because it was such a bad company at, $50 a share. We took a 50% loss on our investment. So they would see those trends and they would see how long, how big, and then they would come to us and say, do you want to file a lawsuit against ABC company? And we could say yes or no. Now, let's say, like I said, Kansas City decides to say the same thing. If Kansas City gets the lead plaintiff, then they're going to get a little bit more, but it becomes a class action. And then that's what historically the custodian did. The custodian, U.S. Bank, would say there was a class action suit on ABC stock and it was in the news. So now we're going to file a claim on your behalf. And that's the money we used to get. Right, Sue?
Yeah, we still get, they
It
still
was
do
still-
that. So we do
Yeah.
PNC. Well, US Bank is still doing it, but
Yeah.
we'll occasionally get, but it's pretty small, a few $1,000.
Yeah.
from
Yeah,
time to
it's not the same thing. It's they are filing a claim on our behalf but somebody's already taken the big lawsuit, right? We're only going to get, if you get these in the mail that say, hey, if you, if, like, for example, I'm trying to think of what would be in St. Louis. What was it? I can't remember, Massage Envy or one of those little places. If you were a customer between this period and this period, then, they didn't agree to anything. Somebody brought a class action. And if you, your name is put in the hat because you were a shareholder. So therefore you can go get a free massage, but it expires between such. So class actions are filed all the time. It's whether you are leading the litigation or you are going to say, oh yeah, I heard on the news and I'm going to file a claim and I'm just going to get my small amount. Because these litigations will make companies pay $1 billion or whatever, right? That's for that pot of money is not infinite, right? So when they talk about these wins, if you are a claimant, then you have to, it's like kind of first come, first serve until the money runs out. So you want to be at the front, or you want to be filing those claims for other class actions pretty quickly too, so that you get your share.
Okay, thank you.
Are there any other thoughts from any other trustees?
Those were excellent presentations, Sue
Mhm.
and Christina and Albert, and Jeff and Gwelda. I really appreciated the information that was provided, and I really enjoyed the presentation.
Yes, very good. We're very good.
Mhm. Well, Sue.
Well,
So-
I guess you have to decide, which firm. Again, we have one already. I know, Jeff, you said we should have multiple. Any thoughts on two too many, three too many? I mean.
Yeah, I guess my general thought is probably, at the very least, maybe just starting with the two of them, and I guess and the question that I had before kind of goes towards that policy, and this was the question to Leviton on, let's say multiple groups are bringing these to the table, and I think that's probably remote. I'm not sure if that ever even would happen, but I think the more of these you have, it probably does warrant thinking about having a policy. And so maybe we can take up Motley Rice on their offer to help out with a policy to draft that. And again, you can have new fund counsel also opine on that as well. But because again, I would just tell you from my standpoint, what my methodology would be is, again, I'm always looking at things as you want to maximize what's in the best interest of the plan's participants. So I think just putting something on a rotation and saying, hey, this guy brought it first, or this guy's next on the rotation, I'm not sure that's as powerful as saying, okay, each one of these groups came to us and made a case as to why they're going to get a better settlement on this thing. So,
So
but
Jeff,
again,
could we,
then- Go
Jeff,
ahead,
could we
Christina.
say, hey, Motley Rice, really want you to focus on the domestic and this other one to focus on the international, because the second one basically said they really do very well on the international. And that way you're not tipping on anybody's toes or stepping on anyone's toes, and they both operate in their own lane. I don't know.
That's a good
Yeah, I
idea.
mean, you could certainly do that. I guess my thought on that too is, and again, I don't want to, I don't want to pick on Leviton on this, but because I feel like probably all of the firms that do the international are overselling it, and you kind of heard them say no one else does it, or we're the only ones doing it, or we're the best at it. But a lot of firms are doing it on the international side. So, but again, I mean, if you wanted to go down that route of saying we're only going to have one firm specialize, I think you could certainly do that. But again, I think that's something that that comes down to having, you probably have to have a policy then that says we have a written policy that says if it's cases XYZ, that it's going to go to this firm. And then here's our methodology for dealing with something if multiple groups come to us with the same case. So I just think the more you have in the mix, the more it probably requires some sort of policy.
Yep. Well, I'm gonna start and say that my preference is Motley Rice, and the reason is the firms are very similar and very capable. However, Motley Rice has been at every NASP since I met in 2009. So apparently he said he started this litigation in 2008, but they've been a big supporter of NASP every single year. And I believe every person who's attended NASP has met Marlon and his team on presenting at NASP or in some fashion or form to educate trustees. And that to me is very important.
Me as well.
Yeah.
So the recommendation, the tentative recommendation was to maybe have one firm handle domestic and then the other firm handle the foreign. So is that the pleasure, or do we just have one firm handle both?
I think they would monitor everything. And
Yeah,
that's
I think so too, Jen.
Robbins Geller, they're monitoring everything, but they have capability on the global. That's
The one we have
specifically
now.
why we went with them, is we didn't have any assistance on the global, but I think they would all monitor everything.
Okay.
Yeah. So we already have global then, right? So we're good on that part, that specialty.
So we would want the local then, I mean, the domestic.
Yeah.
So
And I mean, Robbins Geller could do that too, but again, as Jeff has mentioned, we might want more than one
Right.
to do it.
I guess the other question I have is, Motley said that they would help us draft the legislation or that.
The policy.
The policy rather.
Policy, yeah.
Would that also be something that our legal team would also do, or would we?
Yeah, absolutely. I think we could ask them, we could take something maybe Motley Rice gives us,
And then run it?
as Jeff indicated, and work with
Okay,
Hush Blackwell to kind of
Okay.
fine tune it.
okay.
I like that because then somebody else is drafting it. We're not paying for somebody to draft it. We're just paying for somebody to review it.
Yeah.
Right. Sounds good. Okay, so where are we? Chris?
I do have a motion if we wanna.
I want to hear from other trustees. I don't want to, Bobby, Sheila, who else is on? Hold on, let me see. Albert, Doris, any comments?
Well, you're right, Christina. Every conference I went to, Motley Rice was there. I remember the first time I saw him, he had a big poster board of himself on display. Yeah. And he always talk about his service. And then I also attended one of the NAS conference where he presented to the trustee a workshop about his company.
Yeah, I like Motley as well, and I know they support NASP, and he's been there, they've been there. And they are financial supporters of NASP, which is very important. And plus, I like that they were able to answer everything in detail explicitly about the do's and the don'ts. And it looks like both of the firms that were presented today have handled and won extremely large cases, but I kind of lean on Motley as the one that I would vote for myself.
And then Molly even mentioned they have over 150 lawyers,
Right,
and 20 that handle fraud. So I guess, like you said, he do both of them, global and domestic.
okay.
I think Molly was at the only NAS concerts I ever been to. So my one and only. So but no, I think both firms, and I don't know if we can do both firms, but I think hiring both firms and not just throwing, flipping a coin about who's going to handle this certain case or for certain litigation or whatever. But I think both firms, I don't think it's wrong. I don't think it's anything wrong with doing both firms, or do we have to just have one?
So Albert, we already have one.
We already have one. We were talking about
Adding the second.
second one. One for domestic, and then Sue said the other one already specialized in global.
Right, and I wouldn't say one for domestic and one for global. I mean, again, I don't think it's a flip of a coin if we have three, because I think Jeff or somebody said you can have 2 or 3 firms. Because I don't like the idea of just flipping a coin or having, I'm sorry, not flipping a coin, have one just do domestic and one just do local or overseas, worldwide or whatever. Because they're both are good. The one we have is doing their job right now. Motley is good, and I can't even think of the last one. I think they're all good at what they do. And I just think we choose, depending on how they come to us, is how we choose who we're going to go with for that particular case.
Okay, so this is what I'm thinking. Let's say we do Motley and the one that we already have to do both. Global and then what happens is both of them come to us and we decide which one we want to go with.
Yes.
Okay.
But
And
no, Jeff, what's your opinion? I think 3 firms is too much for our size firm. We're not a CalSTRS or a CalPERS.
Yeah, my general thought
you break it up, Jeff.
is that I think it starting with 2, I'm sorry, can you hear me or no?
Yeah, I can hear you.
Can you hear me? Okay, sorry. So I think it just because you already have one and then adding a second one, I think you have some pretty good coverage because they're both between Robbins Geller and then Motley Rice. You've got 2 pretty big firms with good coverage. And I think maybe a good step would be to start with the 2 of them and you see how it goes for a while. And I think if you get to the point where we find out, hey, we missed out as, in case XYZ because we didn't have Leviton. I don't think that happens, but if that did, then you could somewhere down the road say, yes, we want to add a third, but I think you get pretty good coverage. I think if you let them both do domestic and international, that you kind of get the best of, Robbins Geller might have better inroads, better insight to a good suit on an international company, XYZ, while Motley might have the same kind of insight on a different international company. So I would say if you silo them, you kind of miss out on kind of having each of them and their specialties in their own markets. So our recommendation would be to kind of let them both do everything. And then kind of, if they were to fight over, I shouldn't say fight over a case, but if they're both to bring you the same case, then just sort of require each of them to lay out their case of which one can add more value for the system in their case.
Right, and Jeff, you know, Motley did offer to help us develop a procedure and policy, a draft of one, so
Right.
that we could give to our general counsel, and so that would be great too. So is there any more discussion? Chris, are we ready? What's going on?
Nope. We're ready.
Any other discussion? Okay, Sue. We have we already have the securities litigation.
Okay.
On
I make a recommendation to the full Board of Trustees for the selection of Motley Rice for portfolio monitoring and security litigation services for the retirement system.
Congratulations.
Didn't believe you.
Somebody needs to mute.
It's properly been moved in second. Is there any discussion? I'm gonna do a Lewis and say, is there any discussion?
Okay.
Hearing none. Sue, can I get a roll call vote?
Christina Bennett,
Yes.
Louis Cross.
Yes.
Sheila Goodwin,
Yes.
Bobby Richardson,
Yes.
Albert Sanders,
Yes.
Doris Walker.
Yes.
Okay, so we do have 6, so the motion carries.
Okay.
So this will be brought to the full board at the August 12th meeting.
Okay.
Okay.
And let's see, so we would have to wait till August 12th for them to help us draft this stuff.
Yeah,
Mhm.
start working with them till after the full board would approve this recommendation.
Is that okay in terms of us missing out on something?
Well, I think because we have Robbins Geller
Okay, so
and
we
they're a
good.
very good firm. I mean, I've heard them speak several times and maybe at some point in the future, we could have them come in and talk. They work on some very big cases. I had one of the partners present at the meeting I was at last week. And so they really, they're a very good firm as well. So we have them already on the case, so to speak.
Good.
So, so I think we're good for now, but it's always good to have extra coverage.
Okay.
Will this company be a part of policy?
So you mean the guidelines that would have to be amended? Would
Yes.
fall under
Yes.
the rules and regulations committee.
Yeah, I know. That's me.
Oh, yeah, that's you.
Okay, so you'd have to wait till
The
August.
other one, Lewis, is the one about the credit card. That needs to be put in the manual also.
Right,
Correct.
Mhm.
that all happened in August, right?
No, we did.
Oh, we did do
We
one.
did the
We
credit.
did that.
Okay,
So, Sue, can you work with Doris on after the August meeting to set up a committee and who's your co-chair, Doris?
I have no idea.
I think it's Emily.
It's Yvette.
Oh, Yvette.
Oh,
Yes.
it's Yvette.
I know Yvette is on legislative with me, but
Oh,
I
that's
don't think you read Yvette's name off with policy.
Remember, Sue.
Well, that's the committee. It's the
Okay.
legislative
Okay.
and rules and regulations.
Oh,
committee.
okay, I got you.
Oh,
Yeah, it's all one committee.
Okay.
okay,
Can
so
we
then
get
they
some-
would they'd call a meeting in the fall after August to review these so it looks like, well, Doris, get with Sue because we can't have one in September because you'd have to hire them in August and then they would have to go back and provide us a proposal so that you could review, Doris, and then present to a committee.
Okay, I'll get in contact with Principal Levy to let her know too.
Okay.
Right.
Thank you, Doris, for bringing that up.
Oh, it's no
And is it,
problem.
Okay.
and is it possible to have Robbins Gellers present at some meeting in the future if it's an investment committee or a full board meeting in the future so we know exactly what they're doing and where they're coming from? And then the full board will also probably have to hear from, I guess, the
Mhm.
Motley as well. once
No,
they get hired?
No, the full board wouldn't have to hear Motley, again, but we would want an educational seminar probably, like you said, Albert, from the other firm, just so that, because we can all attend, whether it's a full board or the investment meeting, it's open to anyone to attend.
Okay.
Okay.
Yeah, we can set something up for them to present. It's really interesting stuff. I mean, so
Mhm.
I think that would be a great idea.
So Sue, can you get with the education committee, to be able to set that up?
Yeah, that's trusty business.
Next, Sheila, I think.
Sheila and Angie.
That's
Okay.
me and Angie.
Yes.
Yes.
Okay.
All right. So next on the agenda, Jeff?
Okay, famous last words. I will be brief.
Yeah.
So if you I knew I would draw some laughter on
Oh
that one.
yeah. Oh yeah.
Oh, God.
I promise. Okay, let's flip the Sue. You want to flip to the first
Hold on
page?
one
Is it
second,
me?
Doris, you better mute because you keep saying, "Oh God," we seen hearing all your comments.
Thank you very much, Doctor.
Is it me, or does that look like that piece of paper went through the water?
It looks like it's faded. But it's
I
really
think it's the missing Beatles album cover, I think.
There you go.
That's,
There it is.
yeah. So Sue, if you
Okay.
want to flip to the first page and just take a look at it's a lot of data from the markets, but I think the most important things to see here, it's the focusing on the month, a really strong month for the equity markets, and that's the top box all the way to the left, and you can see 5% for a 1 month period on the S&P 500, and you can see where that brings us for the year to date on the large cap stocks, a little bit over 11% for a trailing 1 year of a little over 28%. So just fantastic things happening in the stock market. If you go to that middle section of the box there, that's the fixed income markets. And again, another nice positive, because if you recall some of the not so great months that we've had fairly recently in fixed income because of the rising interest rate environment, well, that's started to settle out now, and we've got some nice returns for the latest month for bonds as well. So fast forward today in June, and it's another good month as well. So June so far, stocks are up around 3%, and bonds about 1.5%. So a lot of the good news that we've had for the past month or so is continuing into June, and really a lot of that is just based on the Fed is seeing that we're probably seeing a little bit of a calming in the economy. The economy is still really good, but it has slowed down a bit. But more importantly, that inflation we've seen has leveled off and come in a little bit. So the markets have been really enthusiastic about that. The Fed has basically said, we're certainly not going to be raising rates again anytime soon. And what the market's looking for now and what the Fed's talking about is potentially when they start to lower rates. So again, economy's on really good footing, and corporate earnings are good. And so corporate defaults, that's on the bond side of the equation, are good. So all of these things are translating into some very favorable returns in all of the capital markets. So Sue, if you want to flip forward one page. So this is a look at the asset allocation as of the end of May. And again, just how we read that top chart, it's really a graphical representation of the table right below, but the upside down triangles, those are the system's actual allocations for each asset class at the end of May. The vertical bars that you see in each of those gray shaded areas, that's the target. And then the gray shaded area, those are our allowable ranges. So the goal being we want those triangles to be fairly close to those vertical lines, but outside of that, we do give them some tolerance to be at least in the gray shaded range. So you can see from all of the asset classes, the system is in compliance with those ranges, and some are maybe a little further off than others. The one that's probably getting close to its top edge there was on the hedge fund segment. And I know in some of our recent rebalancing that we had approved, I know we were probably going to have a redemption to put in for Grosvenor. Sue, has that gone in yet?
We're gonna do both.
Okay.
I think from both Grosvenor and White Box. So yeah, we are.
Oh, and White Box, right.
Yeah, we're working.
Okay, so once those redemptions go in, that starts to bring that triangle a little closer to our line. But again, we all things considered, we're still in compliance in that segment as well as all of the others. So everything looks good from an asset allocation standpoint, and no recommendations today for any wholesale changes to the target policy allocations. Sue, if you want to flip forward one page. Okay, so here's the rest of the good news. And Bobby, I know you don't like your red, and I think we've fully eradicated the red on both of our pages here. But again, you can see just from what I talked about in the market segment that a lot of that translated over very well to the system's return. So 2.5% for the month brings the fiscal year to date return just up a little over 4%, the latest 12 months at 12.5%. So, and then as we go out further in time, that 5-year number at 7.4, I would say that's probably in line with what we would expect on a go forward basis type of return, given this asset allocation structure and where our current expectations are for all of the major asset classes. That's a pretty fair representation. So the 10-year number, again, not too bad at 6%, and the inception number you see there at just close to 7%. So again, starting with a couple of good markets and some of the structural issues that we've dealt with and keeping on top of our rebalancing, we're really starting to come into a situation where we're looking good relative to that actuarial return assumption, and also looking favorable relative to the system's overall benchmark. So as you scroll down through the asset classes, you can see large cap equities just around 4%. Growth in value, you see there was a continued differential we saw in that asset class. Large cap growth managers up a bit more than the value managers for the month. So if you want to flip forward one. And then you can see where the small caps were somewhere between those large cap growth and value stocks, but at a 4% return. So again, continuing to see some good positive things even in this area of the market, the small caps that have been somewhat out of favor over the past couple of years. So starting to see more investors coming back to that area of the market. And we're also seeing the same thing on the international equities. So you see almost 5.5% for the month, and look where we are at the 1-year period now for international stocks, just creeping up on 20%. So that again, a market or segment of the market that's struggled over the past couple of years, but now we're starting to see that investor appetite come back to those markets. Emerging the same. So it's nice to see a more solid positive return on a monthly basis for the emerging component at 2%, and now bringing that latest 1-year number up to a strong level. So 13% for the latest 12 months. Still have a little bit of work to do to get that 3-year number back above water. But again, we see managers really like the valuations there. And certainly as things calm out, start to calm more on the markets and the interest rate environment where the Fed is, I think we see that risk appetite starting to come back favorably to emerging markets. Sue, we want to flip forward. The global equity piece, again, this is sort of a mix of all of the asset classes. This is the equities plus the bonds. So probably performing right around, I'm sorry, I'm on the wrong asset class. This is global equity, not the global balanced. These are U.S., non-U.S. stocks. This is the Exponence piece. So again, nice month for them, and on a fiscal year basis, starting to make up a little bit of ground, and then their latest 12 months as well. So we saw them struggle a little bit over the past year, but now they seem to be in a good stride and starting to get some of that relative performance back. Sue, one more page forward. Okay, fixed income component. So relative to where the stocks have been, certainly the numbers aren't as favorable, but just sort of thinking about where we are in the environment and the overall contribution level to return that we should expect going forward here, that's improving. So we think we've sort of hit the ceiling on interest rates, and so that kind of takes that that headwind that we had for any of these fixed income managers and starts to shift over to the favorable, nice higher coupon bonds that a lot of these active managers can now select and put in their portfolio and just get us that nice floor coupon return. So again, back on the positive side for the monthly basis, that's good. Still a bit negative on the overall fiscal year, but you see the 1 year number now back in positive territory. 3, we're still underwater a bit, but then the 5 and 10 year numbers, as well as the inception, were back into solid positive return. So what do we think on a go forward basis for where current coupons are in the market, and assuming the Fed doesn't throw us any more loops, we probably think the fixed income component is in the neighborhood of giving us forward looking returns for the next few years in the 5% range. So again, makes a world of difference on this asset allocation structure, because that's really been the asset class that's struggled and has been one of the bigger drags on the overall system return for past couple of years. But again, we've had that fortunate circumstance of the equity markets being very strong and offsetting and carrying us forward to help the plan meet its return objective. Next page, Sue. Okay, and here's the global allocation portion that I started talking about earlier. But in any event, so these are the managers that are really, PIMCO is in the equity markets, the fixed income markets, and they can be a little bit more opportunistic on how they toggle it. But again, for how the markets did for the past month, at a 2.2% range, a little bit behind their benchmark, but again, they've been a little bit more conservative. They've found some of the equity valuations to be running a bit more, so they've been a little bit more fixed income heavy. So that's really what's caused their deviation. But again, that's a piece of this portfolio that we really have primarily for a good diversifier. But over time, what would we expect from this type of asset class? So right now, where we see a 5 year and a 4 year, a 5 year and a 10 year number at 5% and 4 and change respectively, given where markets are right now, we probably think that expected return should be a little bit higher, probably in the 6 to 7% range going forward. So again, should be a good nominal contributor to the overall system's return. The hedge funds, not as favorable for the month, still positive, but you see the fiscal year at 5%, and then a nice 1 year number relative to benchmark at just over 10%. So again, they will participate in the equity markets and the fixed income markets, and they'll toggle those allocations. But really, it's a diversifier and it's a risk reducer in the portfolio, and that's how we have it sized. And as a component, we continue to think that group of managers has done pretty well. Again, on the end trust front, not a whole lot of money there, so it doesn't really move the needle one way or another. One thing I will report on that, and I'm not sure if the trustees received correspondence on it, but they finally came out and said they're going to stop charging a fee on that money. So that is a positive, but I think that's also their recognition of that they just don't think this Peruvian bond situation is going to be resolved anytime soon. So probably expect to see the valuation on that keep lowering, but it's not going to lower due to the fact that they're taking fees out. So that's the good news. And then Sue, I think the next couple of pages are just the alternatives, and we won't have monthly numbers for that, but just sort of a quick update on the real estate market, because that's the one where we probably see the most, the higher magnitude of negative returns for the past year. So that's been a challenged market from both an interest rate perspective and a lot of these managers fighting the tide of investors pulling their money out. And so those are all, that has been causing some softening of those valuations. Good news on that is a lot of managers now in the core real estate space have started to pay out redemptions. So we think that's good news because they're getting better bids on some of their underlying properties. They're able to create some liquidity and get that money back. So is it going to be fast? Is it going to be anytime soon before we start to get a lot of money back here from UBS. It's still it's going to be a while, but also recall that we were in a program that was saving us fees if we committed not to redeem a certain amount of capital. We've now gone to an additional structure on that they've offered that said we're going to give you an even bigger fee discount for money you pull out. So we've currently come out of the redemption queue, and we're getting a larger savings of fees now. But the positive spin to that is they don't have a first come first serve. So which basically says we can get back into line anytime we want for the redemption. So right now we can save extra money on fees, and then once we get to that more frothy turning point in the market where real estate's doing a lot better and UBS has a lot more liquidity, we can come back to the table and resubmit the redemption. So, but ultimately it's just anyone in this market, whether it's UBS or JP Morgan or any of the bigger funds, are just not paying out a ton of money right now. So it's going to be a few quarters down the road. I'll pause there and see if there's any questions. And that was a mouthful, and it's.
I have no questions, Jeff. You were quick.
That's
no red.
I'm not gonna say it's as brief as I could be. I could be a lot more brief, but
Well, I'm looking at this and I
wanted
know
to make sure I want to make sure we had some good color.
Well, Bobby should be happy.
Yes,
I'm happy.
Great job. Great job. What they say, thank you for your service.
Yes, Lord.
Okay.
My pleasure. All is operating well. So,
Are there any questions from the trustees? Thanks, Jeff. Sue, what's
thank
next
you all
on
for
the
your time
agenda?
today.
I think that was it for the agenda.
Did you want to tell them about the correct fixing the IT problem, or you want to tell them later?
Oh, yeah, just a quick follow-up from our meeting Monday with the captioning. There is a setting in Zoom where that should not happen in the future. We've turned off the ability for captioning. So this meeting was already set up, so not sure if that, would have prevented any captioning tonight, but going forward, no one should be able to do captioning wherever that came from on Monday. That setting has been updated so that captioning is not allowed.
Thank you.
Thank you. If there's nothing else on the agenda, can I get a motion to adjourn?
I would like to make a motion to adjourn this investment meeting today, June the.
I second.
Okay.
I don't care what day it is. I'm second.
All those in favor, please say aye.
Aye.
Thanks, everyone. Have a great weekend.
Yeah, and there's no July.
Thanks, everybody. Hope everybody.
Yeah, no July meeting.
Okay, and Sue, I want to say I did stop at your office, and it's always a pleasure talking to the receptionist.
Oh, well, I'm glad to hear
She
you.
always over her. I mean, when I'm talking to her, I'm there at least 5 or 10 minutes, just a general conversation.
Well, good. Thank you for telling me. I appreciate it.
Okay. Good night, everybody.
All right. Good night.
Thanks, everybody. Hope everybody's
Good night,
enjoying their
everybody.
summer. Take care.
Yeah.
All righty.
Enjoy your summer.
Bye-bye.
Bye-bye.